aspects because the topic is due diligence. So it is not merely the preparation of the IM, it is about the due diligence, what all we need to be careful about, how to prepare the IM and how to make it, useful for the purpose it is meant for. Some people call it the heart of the IBC because on this basis only the resolution is based. The key word is resolution and that is based on the IM only. So let us go through what IM means and how it becomes useful. During the CRP, when an RP is appointed, he has to perform various duties. One of them is preparation of IM. It is a document prepared by the RP which provides details of the CD to assist the RA to formulate a resolution plan. So most important sentence here is details of the CD to assist the RA to formulate the resolution plan. So you can understand when we as RPs expect the plan to have a particular information, so from where would that person get those information? He will be getting that from the IM we will be giving to him. And IM is a comprehensive description of all aspects of business and the fundraising proposal. It is intended to provide all the information needed by an investor to make a fully informed decision in a positive and appealing way. It is something which represents a resume of the company or the corporate entity which is seeking investment from the prospective investors, be it the entrepreneurs from the industry, angel investors, or private equity investors, maybe venture capitalists, or the strategic financiers. So IM is one of the most important documents in the CRP, which provides the basis for preparing the resolution plan and consists of information of the CD, which includes list of creditors, amounts of claims, debts due from related parties, number of workers, employees, material litigation, last audited financial statements, provisional financial statements up to the ICD or which is not earlier than 14 days from the date of application, etc. So the purpose of IM is to support the decision making and also to help the decision maker to make a better decision in a particular problem situation. Otherwise, he may not be able to make that decision in the best possible manner without this analysis, which RP will be doing and providing to him. An IM is a comprehensive document that seeks to provide key elements of the CD to the PRA in order to enable them to gauge the viability of the business of the CD and thereafter submit the plan to resolve the state of insolvency of the CD. The explanation provided under subsection 2 of 29 to section 29 explains that the IM must contain all the relevant information which may be required by the RA to prepare a resolution plan for the corporate debtor. So now we'll understand what is the relevant information. But prior to that, I'm sure all of us must have faced challenges while preparing the resolution plan. May I stop sharing for a while and invite anyone who would like to share their experiences regarding what challenges they have faced?
Proper information not received in many cases, whatever is per the guidelines. So in that particular case, we need to prepare the IM without those information. And I think we need to mention there that we have not received the above information which need to be give as per the guidelines.
Yeah. Anyone else would like to share experience regarding preparation of the IM and the problems faced in that? Okay, no problem. Let's go back to the present.
And and what's your view, ma'am, when we are not receiving the proper information?
We will go through all those solutions. First, let us list down the challenges here. So when section 18 talks about the IRP, it says that he shall collect all information relating to the assets, finances, and operations of the CD for determining the financial position of the CD. So most important condition of the CD is the financial condition. Then section 23 subclause 2 states that the RP shall exercise powers and perform duties as are vested or conferred on the IRP under this chapter. Again, RP is also having the same responsibilities. Thus, the IRP, RP are vested with the duty of collection of all information regarding financial details of the CD. And then definitely they have to prepare a document and present that to the PRAs. The IRP or RP in performance of the above stated duties face multiple difficulties in collecting information regarding the correct financial position, correct and complete financial position of the CD. The information acquired by the IRP-RP forms the basis of the IM, and the IM is crucial to establish a baseline of the CD, which is required to be shared with prospective RAs for them to assess the CD before making a resolution plan and before taking a decision whether to give a plan or not. Valuation of the CD is also based on the available information regarding assets and liabilities. So timely preparation of IM and completion of valuation exercise are crucial to the timely completion of proper resolution. Section 19 imposes a liability on the personnel of the CD, its promoters, or any other person associated with the CD to provide all assistance and cooperation to the IRP or RP. The code also provides a relief to the IRP or RP, wherein he may choose to file an application under Section 19, such that the AA may pass an order to the personnel to extend all assistance and cooperation to him. Such directions are given, but generally they do not work much. Thus, there is an obligation under the code and a remedial measure to provide information to IRP or the RP for conduct of the CRP. However, in several cases, the IRP or RP do not have adequate information to prepare a comprehensive IM, leading to further constraints in the conduct of CRP. Even the registered valuers appointed by RP have also expressed concerns in most of the cases that the limited information available constrains the valuation exercise, in some cases giving a limited picture of the CD. The obligation on the CD, its promoters and employees under the code is not easy to realize in practice.
Hello.
Yeah. Yes, who is it? It's necessary to provide for a means for the IRP or RP to seek cooperation, and in the event of non-cooperation to establish the same. It would also be required to establish that the information obtained was partial and inadequate in order to establish non-cooperation. The unavailability of requisite information or documents also constrains the RP from acting upon the questionable transactions by way of which assets may have been diverted or siphoned off. The RP is also constrained for information as a CD and promoters, and sometimes employees also do not cooperate as they might have benefited from such transactions. A financial creditor might have undertaken independent valuation exercise for the CD as a whole, or for the assets hypothecated or securitized with it before extending a loan. Therefore, the valuation exercise is also repeated, and the valuation exercise is repeated from time to time until recovery is made, or during restructuring, or while declaring such loans as NPAs. In such exercises, the creditors come into possession of information and documents related to various assets of the CD, including plant and machinery, inventory, etc. Stock audits are carried out. So those reports are available with the FCs. Banks and other financial creditors who have conducted mandatory audits of the CD for their requirements could share the reports or extracts of relevant portions with the RP. So RP may be able to use those reports in respect of fraudulent transactions as such. And in respect of the other transactions, it may help in identifying the pattern of suspicious transactions and potential related parties, even though period of audit may not coincide with the look back periods, but yes, he may get a fair idea of the patterns of the transactions. And definitely the most important is the inventory and plant and machinery reports. So some idea definitely he can get from the FCs. Considering these challenges, solutions have been provided by IBBI from time to time. One such solution was given via an amendment dated 14th June. In order to strengthen the availability of information with the IRP or RP for the preparation of the IM and avoidance transactions, it was essential that the information available with the CD, its promoters, employees, and creditors be made available to the IRP or RP in a timely manner. So under Regulation 20, Subregulation 2, the personnel, promoters, or any other person associated with the management of the CD shall provide the information within such time and in such format as sought by the IRP or RP as the case may be. So the the responsibility lies on the IRP or RP to seek the information and the personnel and the promoters and other managerial people have the responsibility, are obliged to provide that information under Regulation 20 Subregulation 2. Similarly, the creditors shall provide to the IRP or the RP, as the case may be, the information in respect of assets and liabilities of the CD from last valuation report, stock statement, receivable statement, inspection reports of properties, audit report, stock audit report, title search report, technical officers report, bank account statement, and such other information which shall assist the IRP or the RP in preparing the IM, getting the valuation determined, and in conducting the CIRP. So here it is very important to take a pause and understand the Regulation 20 Subregulation 2 and 3. I would lay my emphasis on 3 because personnel of the CD and the promoters rarely work on our instructions. So it is important to take the banks into confidence, tell them the importance of these PUFE transactions, the importance of the IM, and getting the correct valuation done, so that whatever information and a whole list of documents are listed over here, which are in possession of the banker already. It is only that account was maintained by the branch, and then it was shifted to the legal department, and then it was shifted to some other department, credit department or something. So bankers do not put in sufficient efforts, and they need to be persuaded to find out the records as much as possible and share with the IRP or RP. So the responsibility of IRP or RP is to persuade them to find out those records and share them, because they are also having that responsibility under Regulation 20 Subregulation 3. Again, some changes were made on wide notification dated 18 September 2023 in the CIRP regulations, under which the IRP or RP's obligations were increased multifold. So I have not listed down all the changes that were made on 18 September 2023, but the important ones which relate to our subject today. So the amendment now requires the RPs to not just take handover of the assets of CD, but also verify the asset by asset list of the CD, tally the same with the financials of the CD, and to report the same while making application under Section 19 subsection 2, if not found in conformity with the assets shown in the financials in the books. Also, for condonation of delay of claims filed by the stakeholders, the amendment now requires the RP to file application before the AA. So these two have a bearing on the preparation of IM and on the information to be given to the RA from time to time. Can anyone just elaborate on how these changes have a bearing on the resolution applicant and his decision making? Let us see. The Regulation 3A has been newly inserted in the CIRP regulations. It is named as Assistance and Cooperation by the Personnel of the CD. The IRP or RP shall take custody and control as specified under this regulation from the personnel, its promoters, or any other person associated with the management of the CD of the following. What control and custody is to be taken? The IRP or RP have to take custody and control of the records of information relating to assets, finances, and operations of the CD. Secondly, the assets recorded in the balance sheet of the CD, or any other record referred in clause F of section 18. The personnel of the CD, promoter, or any other person associated with the management shall provide the IRP/RP a list of assets and records while handing over their custody and control, and the IRP or RP may, after taking such custody and control, if deemed necessary, identify persons in whose possession these assets and records will be held. Right? So this is also very important, that IRP shall identify the person in whose possession these assets and records will be held. So this has to come on record. Continuing with the same regulation, where any asset or record has not been handed over, or the list has not been provided under subregulation 2, the IRP or RP shall himself prepare a list of assets and records while taking custody and control of assets and records, and the IRP or RP may, after taking such custody and control, if deemed necessary, identify persons in whose possession these assets and records will be held. Each list of assets and records under subregulation 2 and 3 shall be signed by the parties present and by at least 2 individuals who have witnessed the act of taking control and custody of such assets and records. Earlier also we used to follow this process, but now this has been made mandatory for all. We used to call it, we normally call it Panchnama, which is made, which is signed, which is witnessed, right? The IRP or RP, as the case may be, shall requisition from the personnel of the CD, its promoters, or any other person associated with the management of the CD, the information relating to assets, finances, and operations of the CD referred in clause A of section 18, and such information required under regulation 36, which were required to be maintained by the CD, but have not yet been handed over. So each clause of information which we'll be going through now, section 18 and regulation 36, have been listed over here in what manner we need to take custody and control of them. The IRP or RP shall requisition from the personnel of the CD, its promoters, or any other person associated with the management of the CD, the assets which are recorded in the balance sheet or in any other records referred in clause F of section 18 and whose custody has not been handed over. An application made under 19.2 in respect of failure to provide any asset or record as requisitioned under the code and this regulation shall show presence of such asset or record in the notice of requisition and absence of such asset or record in the list of assets and record taken over by the IRP or RP under subregulation 2 and 3. Right, so we will prepare a list of requisition of the assets which came to our knowledge as per the balance sheet and the record, and in front of that we will prepare which have not been handed over to us, the absence of such asset or record, and that shall be annexed to the application to be filed under 19.2 if the need be. So let me just stop sharing and take a view on this custody and control process. I'm sure all of us have followed this process. If anyone has a different view on this. Anybody wishing to share their experiences? No one is having any experience while taking custody and control. What all problems do we face? Because that has a direct bearing on preparation of the IM.
Yes, many times the assets are not traceable, whatever, and also in some of the cases, assets details are not received from the CD.
Yeah.
Yeah, whatever it's per the financials also. In the financial, only consolidated figures are there, like plant and machinery or other details, but all the assets register or item-wise details are not receiving from the CD.
Yes.
And it's difficult to trace the assets.
So that should come under our list, because at the time of making the initial list where we send the requisition list to the promoters. At that time, that should form part of our list, and thereafter, if it is not handed over, then that should also form of our list. And that list might be, we need to attach that list to the application under 19.2 if we are going to file that.
Yes.
Right. So that is why this process is so important. Let's move ahead. Let's talk about the sources. If anyone has any idea on sources of IM, sources of information for the IM.
Public data also regarding the particular industry.
Yes.
And the details which are already received from the promoters. And details from the ROC website.
Yes.
MCO website.
Most important, yes.
Yeah, and also if it's already having a credit rating agency reports, so we can get data from there also.
Yes, very good.
And also if any civil cases or criminal cases are going on, then we can take details and case download from the particular website of the court also.
Definitely.
Balance sheet also.
Yes. Very important source. But generally, balance sheets are not filed on time. So we normally get 2-3 years old balance sheets, but still we can have an idea on the assets, the inventory, the plant and the factory building, etc.
And also, I think we can get the information to the IP insolvency data information utility.
Yes, very much. Yes. Any other sources? Anyone else? Most prominent ones you have already shared, Manish. Thank you so much. Yes.
If any ED cases are going on, then we can get the details from that particular website also.
Yes, material litigations are really very important
Yes.
to be noted and to be listed in the IM itself. Yes. No one else is having any suggestions. Let us see what my presentation has to say on this. Is this visible?
Yes.
Yeah. So the company website, if CD has a website, from its promoters, definitely we send the requisition list to the promoters, from the creditors, from the financial institutions, from balance sheet and notes to accounts. Generally, the material litigations are listed in the notes to accounts also. The related parties are there in the notes to accounts. From the auditors, we can seek information. From the legal counsel who was representing the CD throughout, he must be having some information on the other cases. The bank statements, once we write to the banks where with whom the accounts are maintained, from there we can get the bank statements and see the pattern of transactions over the past few years, months, whichever look back period is applicable to our tasks, our information. Then the information which is available in public domain. MCA inspection, as you rightly said, income tax and GST portal. Anybody having an idea on how we can get information from GST portal without logging in? We can still get the kind of products they were dealing in, the business locations, the places of business from where the business was being dealt, right? So those information are available only from even from the GST number, and we don't need to get into the login details also for that purpose. The stock exchanges, if the company is listed, legal cases, wherever we have the sources, we can find out the legal cases going on. Other websites which maintain information, like we get some free information and some paid information on the third-party websites also. Business news and publication, if there has been any news about that company, because these days many financial wires and business publications are there which keep writing about the companies and their status. Credit rating agencies, as Manishi has already suggested, CRISIL, ICRA, CARE, etc. They provide credit ratings from time to time, and they provide detailed reports on the health of the companies also. These reports can offer insights into the company's credit worthiness. Business directories like Yellow Pages or Compass, etc. They can provide basic information, including the contact details and business categories. LinkedIn and professional networks. Companies' profile on LinkedIn can offer information about their size, employees, recent updates, etc. Professional networks, as we have already discussed, we can talk to our other groups wherever we are into. We can share the Form A, and then we can seek information if anyone is having any information regarding that company. SARSAI, right, under SARFACI, we can go through that, the charges, etc. if registered over there. Then IU, NESL is the only IU right now, but it serves as a credit and contract repository, and it also has substantial information about the companies now, because now it has become mandatory. I'm sure all of us are aware that since April 2023, it has become mandatory for Section 7 and 9 applications to have the default registered at NESL, which has to be done by the CD, and generally CDs don't do that right now, and applicants are finding it actually practically very difficult to file applications against under Section 7 and 9. But yes, once registered, it serves a lot to the IRPRP. Now let us go through the relevant provisions under IBC and the CIRP regulations, which talk about IM. Section 5, subsection 10 of the code, it defines the IM, it says Information Memorandum means a memorandum prepared by the resolution professional under subsection 1 of section 29. Section 25, subsection 2, subsection G of the code talks about the duties of the RP. The resolution professional shall undertake the following actions, and amongst that, one of the duty of the RP is to prepare the IM in accordance with section 29. Section 29 of the code talks about the preparation of IM. The resolution professional shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the board for formulating a resolution plan. So purpose is for formulating a resolution plan. The resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form, provided such resolution applicant undertakes to comply with the provisions of law for the time being in force relating to the confidentiality and insider trading, to protect any intellectual property of the CD it may have access to, and not to share relevant information with third parties unless clauses A and B of this section are complied with. So it is very important, and it is already written under the code itself, that the RP shall provide the access to the relevant information in physical and electronic form to the RA only after the RA provides the confidentiality undertaking and an undertaking that it shall protect the intellectual property of the CD. Section 29 further has an explanation telling about describing the relevant information, what it means. For the purpose of this section, relevant information means the information required by the RA to make the resolution plan for the CD, which shall include the financial position of the CD, all information related to disputes by or against the CD, and any other matter pertaining to the CD as may be specified. So where it has been specified? It has been specified under the regulations, which we are going through in the upcoming slides. Section 30 of the code talks about submission of resolution plan. A resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A to the resolution professional prepared on the basis of information memorandum. So let us see the connection between the IM and the resolution
मेन
plan.
इकडे आहे त्याचं जिथून आपलं ते गळत होतं ते हा.
So section 29 and 30, 29 and 30 have one thing in common, that when we talk about the resolution, the IM, it talks about information memorandum for formulating a resolution plan. And when we talk about the resolution plan, it is prepared on the basis of the IM. So there is a direct connectivity between the IM and the resolution plan. So one has to be very sure to follow the explanation of the relevant information. And what it means the information required by the RA, what all information an RA might require to make the plan, which shall include not only the financial position, all the information related to disputes and any other matter pertaining to the CD as may be specified. So any matter pertaining to the CD would include any relevant matter, relevant information which comes to the mind of the RP, which might be useful and important for the RA in relation to the financial position of the CD and in relation to decision making by the RA and submission of the plan, formulating the plan and thereafter submitting it. Section 33 of the code talks about initiation of the liquidation. Even that has a reference to the IM. For the purpose of this subsection, it is hereby declared that the committee of creditors may take the decision to liquidate the CD anytime after its constitution under subsection 1 of 21 and before the confirmation of resolution plan, including anytime before the preparation of the IM. Even prior to the preparation of IM, if the RP and the COC have a view, have an opinion that the CD would fetch better results if it goes directly into the liquidation and there is no resolution possible through CIRP process, so an early liquidation decision can also be taken. at any time prior to the preparation of IM or prior to confirmation of the plan. Section 240 of the code gives some powers to IBBI to make regulations. The board may by notification make regulations consistent with this code and the rules made thereunder to carry out the provisions of this code. In particular and without prejudice to the generality of foregoing powers, such regulations may provide for all or any of the following matters, under subclause U, the form and manner in which an information memorandum shall be prepared by the RP under subsection 1 of section 29. So let's see, let us see what the 27th June 2022 discussion paper talked about. That brought significant changes to the regulations. It was aimed to reduce delays and improve the resolution value. And these changes were brought about by 16 September 2022 amendment. So one important change to the EOI timeline was proposed under this discussion paper, and it was thought that on an analysis, it became apparent that for inviting EOI from the PRAs, the IM is not required at this stage. And only the basic information of the CD is required to be given while inviting EOIs. Therefore, IM is required at the time of issue of request for resolution plan. So activity of inviting of EOIs can be started much earlier. If this process of identifying the potential resolution applicants is started earlier, there will be enough time for another iteration of the process if sufficient number of resolution applicants are not identified in the first iteration. So the process, so the timeline of submission of EOIs was reduced from 75 days to 60 days, and the timeline to submit, to prepare and share the IM was increased from 54 days to 105 days. Change in the IM timeline. On the other hand, less time was available for preparation of IM, which is a critical document, which is the basis on which the resolution applicants propose the resolution plans. It was observed that the RPs are not able to prepare and submit the IM to the COC members within the currently prescribed 54 days from the ICD due to reasons such as lack of information, incomplete books of accounts, non-cooperation from promoters, etc. The accuracy and completeness of the information gathered by the IRP or RP has a bearing on the valuation of the assets of the CD. Since the valuers require information relating to the invoice value, date of purchase, condition of assets, etc., such information is also required for forming any opinion on the avoidance transactions and sharing it with transaction auditor for getting audit report. Hence, it is proposed to increase the timeline for preparation of IM so that sufficient time is available to the RP within the overall timeline. The contents of the IM were also discussed and some proposal was given under this discussion paper dated June 2022. It talked about section 29(2) of the code, which provides for preparation of IM by the RP, and the explanation to section 29 provides that relevant information means information required by the RA to make the plan, which shall include the financial position of the CD and all information related to disputes by or against the CD and any other matters pertaining to the CD as may be specified. Further, IBBI via regulations under regulation 36 have provided the mandatory information in the IM contents of the IM. However, it is observed that the IPs and the COC do not pay enough and close attention to the preparation or approval of the IM. This restricts the information available to the RAs and may also lead to complete loss of information. The IM should also be seen as a starting point of a marketing effort for the CD and its assets, and in that sense, it is equivalent to a red herring prospectus issued for market listing. It is also observed that the IM does not reflect the unique selling proposition of the CD, and it does not provide a clear picture of CD's strengths and prospects. It is hence felt that there is a need to strengthen the preparation of the IM and to align the contents to the purpose for which an IM is developed. So it was proposed that the RP shall include as a part of IM a clear picture of the CD's business performance, business evolution details, key contracts, industry overview, including sector fundamentals, key growth drivers, projected business plan, key investment highlights, etc. It should reflect details that would attract or incentivize the PRAs, such as brought forward losses in the income tax returns, input tax credit of GST, key employees, key customers, supply chain linkages, utility connections, and other infrastructure facilities, which will take a lot of time to be set up. Proposed amendment was that Regulation 36(2) may be amended to provide for objectives of the IM, and the following shall be incorporated, which shall read as under. Subclause BA was to be introduced. Company overview, including snapshot of business performance, business evolution details, key contracts, industry overview, sector fundamentals, key growth drivers, projected business plan, key investment highlights, etc. This clause was taken up in the final amended regulations, but the BB, which talks about the factors which bring out the value as a going concern over and above the assets of the CD, like brought forward losses in income tax returns, input tax credits of GST, key employees, key customers, key agreements, supply chain linkages, utility connections, other infrastructural facilities, which will take a lot of time to be provided, etc. This was not taken up in the final amended CRP regulations. So now let's come to the CIRP regulations and the contents of the IM, because the section 29 subsection 2 always talks about such relevant information as may be specified by the board. So what the board has specified, let us go through that. Regulation 36 of the IBBI CIRP regulations talks about Information Memorandum. Subregulation 1 says, subject to the subregulation 4, the RP shall submit the IM in electronic form to each member of the committee on or before the 95th day from the insolvency commencement date. Right? The Information Memorandum shall highlight the key selling propositions and contain all relevant information which serves as a comprehensive document conveying significant information about the CD, including its operations, financial statements to the PRA, and shall contain following details of the CD. So further details are enumerated. Before going through that, let us see exactly how this IM is to be given. It is clearly stated that RP shall submit the IM in electronic form to each member of the committee on or before 95th day. Right? So there are key elements under subregulation 1 which need to be adhered to. But again, it is subject to subregulation 4, which talks about the undertaking from the members of the committee to the effect that such member or resolution applicant shall maintain confidentiality of information and shall not use such information to cause an undue gain or undue loss to itself or to any other person, and comply with the requirements under subsection 2 of section 29. So this sharing of IM shall be subject to subregulation 4, and subregulation 4 talks about the undertaking. Now let us see the contents which have been specified under these regulations. Subregulation 2, regulation 2, subregulation 8 says assets and liabilities, including the contingent liabilities with such description as on the ICD as are generally necessary for ascertaining their values. Now, what do we mean by such description as generally necessary for ascertaining their values? Anyone is having any suggestion on this? Any explanation to this? Such description as may be necessary for ascertaining their values. No idea, no suggestion. Okay, let me tell you, the assets may be having some aging. We may have got some information out of the records and information taken in custody and control from the promoter, and we may have got some information on the aging of the assets. We may have got the exact locations of the properties. We may have got the make, etc. of the plant and machinery, which may be relevant for ascertaining the values. Under the liabilities, we may have got some information on the contingent liabilities, which is very much important for the RA to take a decision in terms of what probably lies under that CD and what all liabilities he may expect, which are not listed in the books, but yes, they are contingent. For example, under the home buyers matters. For example, under the assessments which were going on prior to the ICD, but the taxes, etc., the liabilities and penalties were not crystallized, but all of them will fall under the contingent liabilities. So the complete picture, the holistic view has to be given to the RS for taking a wise decision. Description would include details such as date of acquisition, cost of acquisition, remaining useful life, identification number, depreciation charge, book value, geographical coordinates of the fixed assets, and other relevant details of the assets. Sub-regulation 2 of 36(2) says latest audited annual financial statements. So whichever annual financial statements are available on the MCA website, in case the promoter has not provided you the final signed balance sheets, the audited financial statements of the CD for the last 2 financial years and provisional financial statements for the current financial year made up to a date not earlier than 14 days from the date of application. So that is a critical information which is generally not available, but the RP may get the books of accounts updated and then get the ICD provisional financials prepared with the help of the ex-management. A list of creditors containing the names, amount claimed, their claims admitted, and security interest, if any, in respect of such claims. Sometimes what happens is that the creditors are appearing on CERSAI or the MCA in the charge details, but they have not filed any claims. So they will also fall under the contingent claim, or that information must be given in the IM stating that despite of the fact that the charge has been created, but no claim has been filed by such and such financial institution or a secured creditor. Similarly, particulars of debt due from or to the CD with respect to related parties, they must be mentioned separately. Details of guarantees that have been given in relation to the debts of the CD by other persons, specifying which of the guarantors is a related party, the names and addresses of the members or partners holding at least 1% stake in the CD along with the size of the stake, details of all material litigation and an ongoing investigation or proceeding initiated by government and statutory authorities. Where would we get that? The details of all material litigations, an ongoing investigation or proceeding initiated by government or statutory authorities. For the purpose of preparation of the IM, what all steps do we take? Since inception, we start collecting information about the company, and material litigations are generally found in the financial statements, also the notes to accounts of the balance sheets. And we can get in touch with the legal counsels. But how would we get the information about the proceedings or investigations which are ongoing or which have been initiated by the government or statutory authorities?
From their website, we can check.
Which website?
Like from GST portal, if notices are there, we can check the
Right.
GST website. Income tax, we can check from the income tax website also.
Definitely.
ESI, PF, like we can check from the concerned website also whether any proceedings or anything going on against the company.
Definitely. But what would happen if we don't get the login IDs? Many promoters do not share.
Yeah, no, then we can write to the ESI department also, particular
Yes.
department also.
Yes, that is the most critical step to be taken by the IRP. When
Yes.
the CRP commences, an intimation has to be sent to all the statutory authorities, and whosoever is having any claim may file the claim in a particular form or etc. We can always send to them along with the intimation. We can always send to them the correct form also, so that later there are no problems in the correct form, and all those problems keep continuing for months. They continue, and finally at the end of the plan, even after the approval, sometimes the government agencies come and file objections to the plan, stating that they were not aware that CRP was started again so and so, and we had huge claims and all that. So it is a duty of the IRP at the commencement itself. It should write to all the government agencies so that they can file their claims in time, and ongoing investigations and the amount of liability or penalty crystallized prior to the ICD can definitely form part of the IM, even if the government agency has not yet filed any claim, right? So one is aware that something has been an order has been passed, a decree is already there prior to the ICD. So those amounts have to be considered by the IRP or RP while at the time of preparation of the IM, and should not wait for the filing of claims by these authorities. Till by now, we all have that experience that that the delays that happen at the later stage of the CRP, when it is at its fag end, and at the time of successful resolution, these kind of huge amounts crop up, and these litigations always cause a delay. So therefore, now IRP RP has also been, in October 2023 itself, they have been cast a duty to take into account even the delayed claims. So why not start the process since inception itself, so that we can have a smooth CRP process within the prescribed timelines. The number of workers and employees and liabilities of the CD towards them, whenever you get that data, you can always mention that. From the balance sheet itself, you can get some data. And in case the promoter is not cooperating from the outside agencies, definitely you can write to ESI, PF, Labor Department, etc. Company overview, including the snapshot of business performance, the key contracts, key investment highlights, other factors which bring out the value as a going concern over and above the assets of the CD, such as brought forward losses in the income tax returns, input tax credit of GST, key employees, key customers, key agreements, supply chain linkages, utility connections, and other pre-existing facilities, which might take a long time for the new RA to take. So all the industrial approvals, licenses, permissions, even if they are no longer valid, but yes, you once registered yourself with a particular department, and that registration process shall be saved for the RA. So it will be only a question of the renewal of that expired license or expired permission, right? So the entire process of a fresh registration shall be saved. So you must share, even if it is expired, you must share all the licenses, industrial approvals, agreements, etc. in the IM or as an extra to it. Details of the business evolution, industry overview, key growth drivers in case of a CD having a book value of total assets exceeding 100 crore rupees as per the last available financial statements. So this K, subclause K, is limited to CD having book value of assets more than 100 crore rupees. Any other information which the RP deems relevant to the committee? RP may present it to the committee that yes, this information is seeming to be relevant, and I wish to include that in the IM, and the COC and the RP may decide to consider any other relevant information for the IM itself. A member of the committee may request the RP for further information of the nature described in this regulation, and the RP shall provide such information to all members within reasonable time if such information has a bearing on the resolution plan. The creditors shall provide to the RP the latest financial statements and other relevant financial information of the CD which is available with them. So they are mandatorily required to cooperate. The RP shall share the information memorandum after receiving an undertaking from the members to the effect that member or resolution applicant shall maintain confidentiality. 1. Second, they shall not use that information or to cause an undue gain or undue loss to themselves or any other person, and comply with the requirements under subsection 2 of section 29. What was section 2 of subsection 2 of section 29? It talked about the confidentiality and insider trading. It talked about protection of intellectual property of the CD. And then 36 subsection subregulation 4 also talks about an undertaking with regards to the confidentiality and undue gain or losses. So all these requirements are met only after that. After that, you can share the IM with either the member or the RA. Regulation 36B of IBPI CRP regulations talk about the request for resolution plans. The RP shall, within 5 days of issue of final list under subregulation 12 of regulation 36A, issue the IM, the valuation matrix, and a request for resolution plan document to every RA on the final list. Form filing starts thereafter. Activities requiring filing of Form CRP 7. Timeline for filing Form CRP 7 for the first time is if the information memorandum is not issued within 92 days from the date of public announcement. So CRP 3 from appointment of RP till issue of IM to the members. This includes details of RP, details of registered valuers, handing over of records of CD by IRP to RP, taking over management of the CD, applications seeking cooperation of management, details in IM, non-compliances with the provisions of the code, and other laws applicable to CD. That is to be done within 7 days of issue of IM to the members of COC under Regulation 36. Form 4 talks about is for the period from issue of IM till the issue of RFRP. This includes expression of interest, RFRP and any modification thereof, evaluation matrix and modification thereof, non-compliances with the provisions of code and other laws applicable to CD, etc. This has to be done within 7 days of issue of RFRP. Form 7 is, again, we have covered it already. Timeline for filing Form 7 for the first time is information memorandum is not issued within 102 days from the date of public announcement. Sorry, here there is a correction. This 92 days is written in the CRP guidelines, which has not been amended after the latest amendment. So you should read it within 102 days from the date of public announcement, right? So actual date is within 7 days of T+105 and so on, after every 30 days till the time that activity is completed. So CRP 7 is filed for certain activities which are not completed by their specified dates. A draft specimen was presented by IBBI for what all information and IM should entail. So that was the very first time IBBI facilitated the RPs by giving a specimen of IM. One can have that on the IBBI website. The report of BLRC in November 2015 also talked about the information to be contained in the IM. It says the information collected on the entity is used to compile an information memorandum, which is signed off by the debtors and creditors committee, based on which solutions can be offered to resolve the insolvency. In order for the market to provide solutions to keep the entity as a going concern, the IM must be made available to the potential financiers within a reasonable period of time from her appointment to the IRP. If the information is not comprehensive, the RP must put out the IM with a degree of completeness to the information that she is willing to certify. For example, as part of the IM, the RP must clearly state the expected shortfall in the coverage of liabilities and assets of the entity presented in the IM. Here, the assets and liabilities, including those that the RP can ascertain and verify from the accounts of the entity, their records in the information system, the liabilities submitted at the start of the insolvency resolution process, or any other source as may be specified by the regulator. So the regulator has not yet specified the sources, but we already have a list made with us by practice. So here, the disclaimer about the completeness, the authenticity of the information that has been gathered by the IRP, RP and incorporated in the IM has been talked about. So it is a very important aspect of the IM. that we at suitable places we insert the disclaimers about the genuineness, completeness, and authenticity and comprehensiveness of the information. Sample list of particulars that is required in an IM that was given by the IBBI about the CD, about the promoters and directors, shareholding pattern, assets and liability statement as on the ICD, latest annual financial statements, audited financial statements for the last 2 years, and provisional financial statements for the current financial year made up to a date not earlier than 14 days from the date of application. List of creditors, sample list of particulars continued, particulars of debt due from or to with respect or to the CD with respect to the related parties, detail of guarantees that have been given. This is more or less covered in the regulation 36 sub-regulation 2 only. Now that regulation 36 sub-regulation 2 has been amended so much that this sample list of 2018 is no longer useful. So one glance through the compliances that are required for preparation we have seen. For issue of the IM, while preparing the IM, the RP is required to follow certain timelines stipulated in the CIRP regulations and further comply with other provisions of the code to ensure that the information of the CD, which may contain important business records, intellectual property, or other material information, cannot be misused by the competitors. Hence, subsection 2 of section 29 states that the RP shall provide access to all relevant information of the CD to the RAs after such applicant undertakes to comply with the provisions of law for the timing in force relating to confidentiality and insider trading as may be applicable, to protect any intellectual property of the CD if may have access to, not to share relevant information with third parties unless clauses A and B are complied with. In addition to the above two, he has to give an undertaking under sub-regulation 4 of regulation 36 that the RA only after giving an undertaking from such member or RA to the effect that the information provided in the IM shall not be used by such person to cause undue gain or undue loss to itself or any other person, and to comply with section 29(2) of the code. So this has been given importance at two separate different places. Other compliances related to IM are compliance under regulation 40 subregulation 40B subregulation 1 of the CRP regulation requires the RP to make certain disclosures on the website designated by the board, that is the IBBI website, on the occurrence of certain events. So event-based filings are there under CRP 1 till 8 in such form, along with enclosures as may be specified and required. Therefore, within 7 days of issuing IM to the members of the COC under regulation 36, the RP is required to submit a disclosure in form CRP 3 on the website designated by the board. Additionally, there may be certain occasions when RP is unable to issue the IM within time prescribed under the CRP regulations. These occasions may arise due to non-submission of undertaking by the members of COC, which is required prior to the issuance under section 29(2). In such circumstances where IM is not issued within 102 days from the date of public announcement, the RP shall file a disclosure in form CRP 7 as provided under regulation 40B. Failure to prepare IM. Failure to obtain the requisite documents for preparation of IM by the RP as stated under section 25(2)(g) and section 29(1) of the code, read along with regulation 36, will ultimately lead to the liquidation of the CD. The IBBI may take disciplinary actions against the RP for such contravention. There will be prima facie violation of section 25(2)(g), 29(1), 2082A and section 2082E of the code, regulation 36 of CRP regulations, regulation 72H of the IP regulations, read with clause 13 and 14 of the code of conduct under regulation 7 subregulation 2 of the IP regulations. Even the Ministry of Corporate Affairs in the discussion paper of 18th January 2023 took the which invited comments from the public on the changes being considered, had talked about the disclosure of valuation estimates of assets in the IM, which has still not been proposed or incorporated. But yes, proposal was that presently the IM shared with the RAs for preparing plan does not contain a valuation estimate. It is observed that providing such an estimate to all the RAs will make the procedure more transparent and may help in obtaining better resolution plans for the market. Thus, it was considered to amend Section 29 to provide the IM, provide that the IM shall contain an estimation of valuation of the CB's assets. But this was not considered in the amendments that have been brought into effect while the amendment in October 2023. So this has not gone well with the stakeholders of this market, who must have given their views on why valuation should or should not be considered in the IM. Harshita, shall we take a break here for 15 minutes and then we continue with the case laws on the subject?
Yes, ma'am, we can take a break.
Yeah, sure. Thank you.
யாருது பெங்களூர் கம்பெனியா அந்த
Harshita, let's start. Harshita, are you there?
Yes, ma'am.
Yeah. Let's start. This is visible, right?
Yes, it is visible.
So I just wanted you to have a look at the changes made via amendment introduced by the notification dated 18th September this year to the CRP regulations, and only two of them I have listed for your consideration here. The one is that was the regulation 3A that we have seen in detail, how to take the control and custody of the documents of the financial information and the assets of the CD. And thereafter, the condonation of delay of claims. Now the claims are allowed to be filed up till the approval of the resolution plan. So for the condonation of delay of claims filed by the stakeholders, the amendment now requires the RP to file application before the AA, but you cannot just reject them on the basis of the delayed filing. What is the impact of this amendment on IM and the responsibilities of the RP? No one? Anyone having any view on the impact of the amendment of delayed filing of claims and which are to be accepted by the RP, and RP has to make an application to the AA for accepting the same, condoning the delay in submission of the delayed claims? Manishi?
No.
No. So you will have to update the IM with respect to those claims, no? So updating the IM is an ongoing process now. So every time you get a new claim, you need to accept that after getting its delay condoned by the AA, and every time you need to update the IM. That has to go to the, if it has a material impact, then it has to go to the COC and to the RAs, right? It may be having a significant impact on the values, right?
So, madam, you want to mean that that latest amendment of 90 days is there? So that
Yeah.
you want to mention? But
Yes.
for that purpose, why RP should apply for condonation of delay?
See, once it is written in the regulations, then you can't ask why, because this was also not forming part of the discussion paper and we have not given any views on this. This has come to us only after the amendment has been announced. Probably the logic behind this has been to give some respite to the stakeholders and to reduce the litigations, the delays caused by the litigation at a later stage of the plan, at the time of approval of the plan. Once the application is filed for approval, thereafter 2 to 3 years were being taken by the NCLTs only because of the objections being filed by the other stakeholders whose rights were prejudicially getting affected by that plan. So to reduce those litigations at that stage, when the value is discovered, plan is in hand, it is legally viable, financially viable, commercially taken, the decision has been taken by the COC, and thereafter the interests, definitely whose interest is affected, that stakeholder has a right to file an objection, but that should be taken care of much beforehand. And the RP has double responsibility now to take care of the interest of all the stakeholders, preempting them. And at the time of, that's why I say, now, why to drag these issues for the last moment? So you inform all the stakeholders, you write to all the creditors. That has been given in the regulations also, that you need to write to all the creditors, even if they are not forming part of the database that has been provided by the promoters. You can get that on the GST portal. You can get the addresses, you can write to them, you can write emails. for filing the claim, so that this process is not dragged. But yes, this has been introduced for us and we have to abide by this. So this might have an impact on the financial value of the CD. So the IM will need to be updated regularly, more frequently than earlier we were updating that. There has been a latest discussion paper of 1st November 2023. IBPI has published a discussion paper on amendments proposed to the CIRP regulations again. Comments were invited till November 22. It talked about disclosure of fair value in the IM. Again, this was proposed first in January 2023. The MCA had proposed this amendment, but this was not taken up in the September 2023 amendment. But now again, it has been proposed to encourage more viable and better valued plans. Regulation 36 of Regulation 2 of the CIRP regulations is proposed to be amended to provide that the IM to be shared with the prospective RAs shall include the fair value of the CD. Thereafter, it also talks about the mandatory contents of the resolution plan for the effective implementation of the plan and to mitigate the impact of disputes or litigations in respect of distribution of amounts under the plan. It has been proposed to amend the mandatory contents of the plan under Regulation 38 of the CIRP regulations to provide that a resolution plan shall be prepared in two parts. Part A encompassing the inflow, that is payment under the plan, total value of the resolution plan, payment of resolution process cost, payment schedule, feasibility and viability of plan, etc. And part B, dealing with the distribution to various stakeholders. Further, the COC will be required to recommend whether a resolution plan will have provision for separate approval of part A and part B by the AA. It has also been proposed that any disputed amount can be deposited in an escrow account till such dispute is resolved or attains finality. So now the relevant case laws regarding the information memorandum. There have not been many cases filed and many observations, directions or decisions given by NCLT, etc. on this subject. But yet a few of them are listed in this presentation. One is IBC Singapore Private Limited versus COC of Educom Solutions Limited and another. The Honorable Supreme Court of India in the matter of IBC Singapore versus COC of Educom in the matter of Kundan Care Products Limited versus Mr. Harmeet Gupta and others dealt with the duty of the RP to provide accurate information of the CD and made the following observation. Under the IBC, there is a duty upon the RP to collect as much information about the CD as is accurately possible to do. When such information is communicated through an IM to the RA, the RP must be careful to clarify when its information is not comprehensive and what factors may cause a change. Therefore, our disclaimer has to be properly worded. The events that or the factors that might cause a change in the values or of the assets or contingent liabilities, etc., must be properly highlighted. And at every stage, we must give complete information regarding our apprehensions about any future changes. Kushal Limited versus Karthik Baldwa. In this matter, Honorable Enclad dealt with the allegations upon RP, wherein the appellant stated that the RP failed to disclose the ongoing assessment proceedings under the Income Tax Act, which were pending during the preparation of the IM, and also alleged that the IM depicted a higher production capacity of the CD, while the actual production capacity was comparatively low. So there were two allegations. The Honorable Enclad, while dealing with non-disclosure of ongoing assessment in the IM, observed that another contention of appellant is that pending tax proceedings are not disclosed in the IM by CIRP. In fact, the CIRP disclosed the tax liability, and appellants at point number 51 of the resolution plan agreed as follows. Taxes or tax shall mean any and all present and future direct or indirect claims for tax or levy or impost, duty, cess, statutory dues or other charge of a similar nature, including any penalty or interest payable in connection with any failure to pay or any delay in paying any of the same, including on gross receipts, sales, turnover, value addition, use, consumption, property, service, franchise, capital, occupation, license, excise, documents such as stamp duties and customs and other taxes, duties, assessments, or fees, however imposed, withheld, levied, or assessed by any government authority. As the appellants themselves agreed to pay the future liability of taxes, non-disclosure of any pending cases as to the assessment is not a ground. On the other hand, RP is under obligation to disclose pending cases, but not the assessments. Hence, non-disclosure is not a ground to conclude that CRP made any misrepresentation. Here, CRP is referred to as, should be referred to as RP. Further, while dealing with the second contention, the Honorable NCLAT took into account the observations made by the Honorable Supreme Court in the aforementioned judgments and made the following observations on the relevant information to be provided by the RP. In the explanation annexed to Section 29, the word relevant information is explained. It means the information required by the RA to make the resolution plan for the CD, which shall include financial position of the CD, all information relating to disputes against the CD or any other matter pertaining to the CD as may be specified by the IBBI regulations. So RP is not responsible for the correctness of the information. So this is a favorable judgment in favor of the RP. NCLAT goes on saying, therefore, the word relevant information referred in Section 29, subsection 1 of IBC is only an information required by the RA. That is, appellants herein to make resolution plan for the corporate debtor. Hence, the RP disclosed the information based on report of Midcon, which was available to him. And he is not an expert to make an assessment of the production capacity of the industry. Therefore, he only disclosed those details regarding production capacity, which were based on an earlier report submitted by Midcon. Such information is relevant for the purpose of making a resolution plan for the CD by the RA. Thus, resolution professional disclosed relevant information, enabling the RA or appellant to make appropriate application by submitting resolution plan for the CD. Such act would not amount to fraudulent misrepresentation. RP only relied upon the third party report, which were experts. Therefore, after perusing the aforementioned judgments passed by Honorable Supreme Court of India as well as Honorable NCLAT, it becomes clear that although the RP shall strive to provide the most accurate information related to the CD as available with him, he is not expected to make an assessment of the information and reports referred to in the IM. So we must write our disclaimer properly. In the matter of Bimlesh Bhardwaj versus Value Infratech India Private Limited, Honorable NCLAT directed the IBBI to investigate the conduct of the RP by taking note of the fact that the RP resorted to ingenious way of circumventing his responsibility, including that of preparing an IM and ordered. From the minutes of second meeting of COC, it is clear that the RP has resorted to very noble and ingenious way of circumventing his duties imposed upon him in the IBC for preparation of IM, exclusion of time to extend CRP period, and inviting EOIs for resolution plan for the CD. Thus, we find that the COC was not constituted in accordance with the provisions of the IBC. In the matter, the CRP was not pursued with fairness and due diligence by the RP, and the resolution for liquidation of CD was taken in a meeting with an improper voting share ascribed to respondent number 4 and taken in unseemly haste. These are actions of omission and commissions, which we cannot absolve the RP from his conduct, should be investigated by IBBI, and action as appropriate may be taken against the present RP. Disciplinary proceedings. In one of the disciplinary committee actions against one RP, one among the charges was non-preparation of IM. The said resolution professional was issued with a show cause notice. The allegation contained in the show cause notice is for contravention of the provisions of the code and regulations thereof for non-preparation of IM. In this case, the office premises of the CD were sealed and were under the control of Chennai Metropolitan Development Authority. On an application filed by the RP, that is Mr. Armugam, AA, wide order dated 11 July 2020, directed the ex-directors to make an application to CMDA to enable the RP to take possession of all documents and records. It requested the CMDA to cooperate with the RP to retrieve the records from the office of the CD, which was sealed by CMDA. In compliance with the said order of AA, CMDA, via its letter dated 14th August 2018, informed the RP that CMDA proposed to deseal the building for 1 day to allow him to take the required documents, books of accounts and records on 17th of August at 11 a.m. Since the resolution professional did not turn on that day, CMDA again offered opportunity on 4th October 2018. The show cause notice alleged that the RP failed to inform his duties and also failed to obtain requisite information documents for preparation of the IM. The resolution professional submitted that the AA had exculpated him of any blame for the failure of CRP process. The AA further observed that the RP has made efforts to access the records of the CD. However, the same could not be done due to non-cooperation of promoter directors of the CD, as well as because of the registered office of CD was locked by the third party, that is CMDA. The same conclusion has been reached by the NCLAT in its order dated 28th May 2019. The resolution professional submitted that the property was not desealed on 17th August, and the officials of CMDA told the RP about desealing when he approached them to their office. He submitted that the it was desealed only once, that is on 24th August. And that letter dated 21st August conveying that about the desealing of the property of the CD on 24th was received by the RP only on the 25th of August. And because of this reason, he could not be present for the desealing of the property. Therefore, he was not faulted for non-preparation of the IM. The ex-directors, in one of the matters, the ex-directors of CD did not cooperate with the IRP or RP from the very inception of the CRP. The non-cooperative attitude of the ex-directors led the RP to file 9 applications before AA under section 19 of the code during the CRP, wherein it was directed by the AA that the ex-directors should cooperate with the RP, and an undertaking to that effect was also given by the ex-directors to the AA. The adjudicating authority also observed that although the resolution professional had made efforts to get access to the records, however, he could not lay hands because of the non-cooperation and CMDA. The registered office was not desealed on 17th, and when the RP approached the office, he was informed that desealing has been deferred. The letter dated 21st August was received by him on 25th August, and therefore he was not able to be present for the desealing on 24th. Therefore, the disciplinary committee observed that the submissions made by RP in non-preparation of the IM were justifiable. Therefore, no action was taken against him for the charges alleged in the show cause notice by the order dated 5th January 2021. So there are certain matters wherein such decisions are also taken. In one of the discussion papers only, I found this DC order, order dated 5th March 2021. It examined the aspects related to appointment of advisory services firm. The scope of work for the firm included preparation of IM. As per section 25(2)(g) of the code, it makes it mandatory for the RP to prepare the IM. Thus, preparation of IM is the primary function of RP, and by involving the firm, the IP had outsourced activities and not taken reasonable care and diligence, and not performed his functions in the manner specified in the code. Therefore, while you are appointing the professionals or taking support service from an IPE, etc., you must make sure that wherever it is the certain tasks are meant to be undertaken only by the IP, the IRP or RP, and they cannot be outsourced. So preparation of IM cannot be outsourced. In some other matters, in one of the matter in Vijay Kumar Jain versus Standard Chartered Bank, the regulations make it clear that these persons were vitally interested in resolution plans as they affected them. Thus, under Regulation 36 of CRP regulations, the IM that is given to each member of COC and to any potential RA will contain details of guarantees that have been given in relation to debts of the CD. So earlier, this was not part of the regulations. Later on, this was made a part of the regulations itself. in JP Kensington Boulevard Apartments Welfare Association versus NBCC. Due adherence to the timelines provided in the code and related regulations and punctual compliance of the requirements is fundamental to the entire process of resolution. And if a claim is not made within the stipulated time, the same cannot become a part of IM to be prepared by IRP. And obviously, it would not enter into consideration of the RA as also the CUC. In the very scheme of CIRP, a resolution applicant cannot be expected to make a provision in relation to any creditor who has failed to make a claim within the time specified and extended time as permitted by Regulation 12. So now this situation had also undergone a little change. But still, it is a duty of the IRP or RP to make provision for those claims which have not been filed but which are under the knowledge of the IRP or RP or which are forming part of the books of accounts. And it can be clearly made out from that the claim that the creditor exists. However, due to certain reason, he may not have filed the claim. So that later on, if a claim, delayed claim also comes to the knowledge of the RP, it can be brought to the knowledge of the RA, and RA should have made the correct provisioning for that claim in its value at the time of submission of the plan itself. So these are the provisions related to the preparation of the IM, and I think I have covered most of the points. In fact, all the points available on the IBBI, which they wish us to take care of. And the sources of information is also taken care of here. Anything anybody would like to add to the discussion here? Any questions or suggestions or experiences if you wish to share?
I have a question. Can I ask?
Yeah, please.
In my case, this is regarding this amendment which came in 18 September 2023. I have received a claim which was not accepted by me because it was given late by the OC. Now, after this 18 September, I have not issued RFRP as of now. I have not given EOI. Now, am I obliged to accept the claim after the amendment of 18 September?
Yes. That amendment is also applicable to the ongoing CRP cases.
Okay.
Yeah.
Thank you. And one more.
Yeah.
And there is no need to submit IM to NCLT or IM to NCLT or IBVI, no?
No.
Okay. Okay.
But yes, the list of creditors, if updated, that you need to file. Both with IBPI and NCLT. Only the list of creditors.
Okay. And now there are 9 FC members. After this amendment, I will have to add one more. There is one more claim received after this, before this amendment, but after the due date of the claim submission. I have to go for authorized representative appointment because the number of FC will be 10.
Now, come again. It has come after the due date, last date of submission of claims, even the extended date.
Yeah,
right?
There were before the during the COC formation, there were 9 FC. One FC gave a claim very late, so he was not admitted. Now, basis this amendment of 18 September, I have to admit him. Number of FC will be 10. So, do I have to make an appointment of authorized representative?
Yes.
Okay.
But that will be only after taking condonation from the NCLT.
But condonation is only if the claim is received.
Admitting, yes.
But there are 2 categories, madam. What I understand, what was my understanding is that claim received before RFRP and claim received 7 days before the voting plan, something of that sort,
Yeah.
if I'm wrong.
Yes.
So condonation is there in both the cases. Yeah?
No, condonation is there if it is received after 90 days.
So the RP has to go for condonation now.
Yes, RP has to go.
One query is there, ma'am, regarding IM. We
Sorry,
need
yes.
we need to update IM on means once the timeline was completed. Suppose we have received the claim as we discussed that we need to update the IM. So is there any timeline that within how, because other than this claim, we may have some other material information also, like if some cases are going on and date was decided or may not be decided. So whether means we need to update the IM within some timeline basis, or can you just enlighten on about that?
See, there's no timeline given in the regulations for this purpose. But
Yeah.
yes, we depending on the stage of CRP you are going through. For example, if the plan is being formulated by the RA, or discussions are going on or negotiations are going on for the plan value, then you must update with the relevant and material information having significant value impact on the plan or the financial position of the company. You must inform immediately, right? So there is no timeline prescribed as such, but you must apply your own wisdom on which stage of CRP you are into, and
Okay.
whether the stakeholders require that information immediately.
Okay. And we need to share with the COC and concerned RA also.
Yes, all of them. Once they have
Yeah.
shared the confidentiality undertaking, etc., then for the updates,
Yeah.
need to just share the update or updated
Okay.
pages, or maybe whichever way they are comfortable.
Okay. And one query that confidentiality is compulsory from the COC, but in some of the cases they are giving means lately confidential.
No, then you cannot share. You cannot share the IM without
Okay.
getting confidentiality.
So
So
that
what is
we can
recommended is
email.
you start asking for confidentiality undertaking in the third COC, approximately in the third COC itself. While you are engaging valuers, you need one undertaking for them for the summary of valuation. You need one undertaking for sharing IM. So start asking for that even prior to the preparation of IM. By that time, they will understand the importance, and when they will start asking, and when there will be the right time to share, the confidentiality would have already come to you.
Okay. Thank you.
One more question, madam.
Yes.
One of the OCs gave a claim maybe 4 months back. Can you give a fresh claim form on the current day? Or can he altogether give a new claim? Or how is it? He wants to revise
I
his
think
claim.
there is no bar on giving a new claim if they are revising their claim and they have certain information which requires a revision in the claim or the claim form, then they can. You
Okay,
have
but-
to then apply your mind on merit basis, whether you can accept that, whether you need to take a condonation or delay, or whichever stage you are operating into, and on the merits of the claim. If any of the stakeholders have come across a relevant material information at a later stage, then they may revise.
Okay. And one more question regarding the earlier one. If I am admitting the 10th COC member, do I have to take a permission of the current 9 COC members, or I can just admit
You
him?
need to inform them. You need to
Yeah.
inform before admitting him, but it is not about taking permission.
Okay.
It is RP's duty. RP will have to admit in case it is valid, it is acceptable on merit.
Okay. Thanks.
So, no other questions relating to IM?
In one case, the IM has not been issued. They have asked for an NDA, but the COC has not given NDA. Can the COC go for liquidation directly without Okay, so then in that case, IM did not be issued for those members, COC members.
Yes. If they don't require it, if you don't consider that there is a requirement of inviting resolution plans only, then there is
Yeah.
no use of IM if COC has decided that with relevant with the correct majority percentage of voting.
Okay, okay. Thanks, ma'am.
It's seeming that I have only read the entire law, and I don't know how many of you, you have listened to that. There are no queries, and we are all aware about the contents of the IM and due diligence while preparing the IM. So there are no further contents I have to share, Harshita. If there are no further questions, we can just close the session.
Yes, ma'am, we can.
Yeah. So
Okay.
shall I request everyone to just give a smile once?
Yeah, ma'am.
So at
On the
least
chat
people are
box, no?
listening to me. That shows that everyone is listening
On
to
the
me.
chat box?
No, on your camera, please.
Okay. Thanks, ma'am.
Thank you, Ji. Thank you very
Thank
much.
you. Thank you very much.
Quite learned people are there around. That is
Thank
why
you.
there is no question.
Thank you.
And subject had been quite simple. So I would like to request Mr. Sigdar here. He's a senior IP. So he can share his views on the preparation of IM and what we should take care as RTs while preparing the IM.
Thank you, ma'am. Actually, I think you have covered almost all the points. There is nothing more to say. You have done it very meticulously. You have followed all the points which was required to be covered. Definitely, we have to see to what maximum information that we can provide to the PRAs so that they can make the plan very effectively. That should be our aim. And I think you have taken care of all the points very well. Thank you, ma'am.
Thank you. Thank you, sir.
Thanks.
Anybody else would like to share any further? I think the law is very clear now, and we must look at the last point of the regulations, which says any other information which might seem, which is deemed important and relevant. So that is where we need to put focus on to get the correct resolution plans, the appropriate ones. So thank you very much. Thank you for listening patiently.
Thank you.
Thank
Thank you, ma'am.
you.
Thank you,
Thank you,
ma'am.
ma'am.
Thank you,
Thank you.
everyone.
Thank
Thank
you
you,
very
ma'am.
much, madam.
Thank you.
Thank you.